live. There we go. Good afternoon, everybody. Today is Monday, February 15th, 2021. I hope you all had a great weekend, Valentine's Day and President's Day. We have a few bills before us that shouldn't take too long. So without further ado, if we can get started with House Bill 56, Delegate Boyce. It looks like a reintroduction from last year.
House Bill 56 authorizes an employee of an employer with 15 or more employees to use earned paid leave for the death of an immediate family member.
So this is existing leave that expands the use of it, of earned leave, what they can use it for?
Right. So this bill is amending the Flexible Leave Act, and the Flexible Leave Act is basically the precursor to the sick leave law. So that was a law that said that an employee of an employer with 15 or more employees would need to be able to use their own earned paid leave to care for an immediate family member, as if they needed to help care for the person's health needs, they could use that leave instead of just for themselves. They could also use it to care for an immediate family member. So this bill is adding bereavement leave to that. So the employee would be authorized to use their earned paid leave to, go to a funeral or something related to that, to the death of the immediate family member.
Any amendments?
Nope.
I have one question, Mr. Chair.
Yep.
Laura, and I guess I forgot, what was the enforcement mechanism for this bill, or was there one?
Well, it's adding bereavement into the existing Flexible Leave Act, and under the current law, if there's a violation, let's see, whenever the commissioner determines that there's been a violation, the commissioner is required to try to resolve an issue involved in the violation informally by mediation, or ask the AG to bring an action on behalf of the applicant or employee. And the AG is authorized to bring an action in the county where the violation occurred for injunctive relief, damages, or other relief.
Okay, I'm just trying to watch what bills we do this year to make sure we're not creating any new areas of law for unseemly plaintiffs' attorneys to jump in, but this doesn't sound like that, so I appreciate it. Thank you.
I've got a question, Mr. Chair.
Delegate Walker.
Did we take out the language, I think last year when it first was introduced, did we take out the language that dealt with a pet and a cousin of a cousin's friend's dog and stuff like that?
I believe it's as we sent it out. Is that correct, Laura?
So pet was in the bill last year. The committee took it out. It's not in the bill this year.
Okay.
That the only difference with the bill as passed by the House last year is that this year's bill makes it clear that the leave could be taken for death of an adult child. The way the Flexible Leave Act is written, it says like a minor child or someone who basically is dependent. So you could have this absurd scenario where an adult child died and the person under the law wouldn't be authorized to use their earned leave for that, bereavement.
All good.
Mr. Chair.
Is that
Darren?
Aaron?
Yeah,
Darren.
Laura, just real fast. I guess, is there any reason for the bill? Have we had instances where somebody was forbidden to take leave, a bereavement leave? Is there a reason this bill's there?
I'd have to, honestly, it's been a while since we had the bill hearing, so I can't recall. Let's see, the sponsor just provided a lot of information about how unsupported grief causes a lot of mental and physical problems for a worker. That a lot of employers already are offering like separate leave for bereavement. She said some large employers offer up to 20 days. Last year, I recall a witness came and the person was specifically seeking pet coverage for pets. And she spoke at length about how her pet passed away and she didn't have any ability to take time off. And so I don't recall there being testimony this year.
That was about a pet, though. That wasn't about a person.
Right. I don't recall there being.
Okay. Go ahead. I'm sorry.
I don't recall there being specific testimony, oral testimony. We had some support testimony in writing, but I don't have a specific example that was presented in the bill file.
Okay, and what about somebody with 15 or under employees?
14 or fewer is not
14.
covered by the Flexible Leave Act, so those employers would not need to authorize someone to use their paid leave for this purpose.
Okay, thank you. That's perfect.
Anyone else?
Chair, can I briefly chime in?
Yep.
Just want to say, in certain times, colleagues, this is the delegate Aaron's question. We just have to provide some clarity on what our intent is as a body. And on this one, Steve, I believe that when it was brought to, I believe this is our subcommittee. I know we worked on it. I just don't know where, if it was committee or group or whatever, but the goal, we didn't really look to see what issues were. We just want to make sure we create, cleared all the hurdles that might be in the way, because we wanted to make sure our intent was known and that we wanted people to take leave and be able to take that leave, not extra leave, but that leave for, bereavement. So I believe, even though we didn't identify a specific problem, we just wanted to provide clarity for the law.
Anyone else?
Move favorable.
Second.
Motion for favorable in a second. Let's see. Any further discussion? If not, Madam Vice Chair,
Yes.
Delegate Brooks,
Aye.
Delegate Fisher,
No.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yep.
Delegate Pippy,
No.
Delegate Mounts,
No.
Delegate Wilson,
Yes.
Delegate Impalaria,
No. No.
Delegate Branch,
Yes.
Delegate Valderrama,
Aye.
Delegate Walker,
Yes.
Delegate Chi,
Yes.
Delegate Adams,
No.
Delegate Aaron's,
No.
Delegate Fennell,
Yes.
Delegate Charkoudian,
Yes.
Delegate Howard,
No.
Delegate Crosby,
Aye.
and Delegate Watson.
Aye.
All right, motion carries. Next bill, please.
Let's try again. HB 127 is the Maryland Paint Stewardship Bill. This bill basically requires producers of agricultural paint sold at retail in the state to establish a paint stewardship program and submit it to the Department of Education. Paint stewardship program is basically a recycling, reuse, and end of service / use program for agricultural paint. ECM is secondary on this. ENT is primary. They have already passed this out of the committee, and they moved it favorable with no amendments.
Move favorable, Mr. Chairman.
Chairman, what the vote count was in ENT?
It was party line vote,
Okay,
16-7.
thank you.
Second.
All right, moved and seconded for favorable. Any discussion? Madam Vice Chair,
Yes.
Delegate Watson,
Yes.
Delegate Crosby, Delegate Crosby,
You know what? I think he's frozen. He just sent a text saying he was frozen.
all right, I'll check back with him at the end. Delegate Howard,
No.
Delegate Charkoudian,
Yes.
Delegate Fennell,
Yes.
Delegate Aaron's,
No.
Delegate Adams,
No.
Delegate Chi,
Yes.
Delegate Walker,
Yes.
Delegate Valderrama.
Aye.
What was that?
Aye.
Delegate Branch,
Yes.
Delegate Impalaria,
No.
Delegate Wilson,
Yes.
Delegate Mounts,
No.
Delegate Pippy,
No.
Delegate Jackson,
Yep.
Delegate Carey,
Yes.
Delegate Rogers,
Yes.
Delegate Turner,
Yes.
Delegate Queen,
Yes.
Delegate Fisher,
No.
Delegate Brooks.
Yes.
Did Delegate
Mr. Chair.
Crosby get back in?
Yeah, I got back in. Aye.
Right. Motion carries. Let's go to House Bill 148, please.
Yes, House Bill 148 adds revisions to the Maryland Personal Information Protection Act. These revisions include adding genetic information to the definition of personal information, requiring a maintainer of personal information to ensure that personal information is protected, requiring a maintainer of information to notify a owner or licensee of personal information within 10 days of a breach, requiring an owner or licensee of personal information to notify a consumer within 45 days that there has been a breach, and add some information that the businesses have to report to the Attorney General's office in the case that there is a breach of personal information. This bill had one amendment, but it was a clarifying amendment, and that specifies when substitute notice can be given for a breach of personal information.
Amendments. Or was that it?
That was it.
All right. Let me take a motion on the amendments, and then I'll go to Delegate Howard.
Move favorable on the amendment.
Second.
Delegate Howard.
So it also includes the language about maintainers.
Correct.
So it says that maintainers of the data have to notify the businesses within 10 days, and then the businesses have notification within 45 days of,
Correct.
okay. What methods of notification?
So direct notification is what is needed right now. And that's basically if you have their address, their actual physical address, email address, their phone number, that's considered direct information. If you do not have that information, then you can provide substitute notice. Substitute notice is emailing them and then also letting them know, hold on, it says major print or broadcast media in geographic areas where the individual affected by the breach likely resides. But you can only give substitute notice if you do not have enough information to provide direct notice.
Okay, so a lot of businesses have email address, and those are a lot of opt-ins, you know, as far as, hey, would you like to sign up for our email list? A lot of people don't do that, so they would be outside of that email notice. So major publication, would that include social media?
It says major print or broadcast media. So I don't think so, no.
Well, CT's shaking his head no as an attorney.
Yeah, I don't think so.
He's an attorney too.
Yeah. So we got one attorney. Okay, so you both say no, that social media. So that would have to, what would that be then? What would that notification platform be then?
Like a newspaper or broadcast media is like CBS or whatever your local WBAL.
So a small business that was notified of a breach by a maintainer would take out a business ad or pay for notification through WRNR or
Well, that's substitute notice. So if they have direct
Well-
notices, written notice into the most recent address. So if they have that, then they can do that. Or if they have electronic mail, then they can send it through email. Or if they have their phone number, they can send it through that.
Is
So
there
you
a
only-
cap on the size or gross revenue of the business? A lot of these small businesses are just that, small businesses.
No.
Okay.
So that part, that's no.
No.
It doesn't.
Okay, so it would apply to any business, including like a snowball stand. That I mean, if they have a customer list, right?
In theory, if you know they had information that was breached.
Okay.
Delegate Aaron's.
Yeah, thanks, Mr. Chair. Just real quick, one of the other concerns about the bill was the notice, going from 10 days or 45 days to 10 days. Has there been any consideration? Because that seems like one of the big hits that I got, the comments I got, that was a big problem for the industry.
Yes, to my understanding, that had been worked out already behind closed doors. I believe beforehand, it was actually a shorter notice and they compromised to make it 10 days and 45. I don't know if.
That, could I?
Sure.
Yeah, yes, Delegate Aaron's, yes, that was we worked that out over the last couple of years with the industry, with all of the players in the industry. As a matter of fact, the original bill that was brought in last year was 7 days. So we worked it out to 10. And that's on the maintainer. So once the maintainer discovers that they've been breached, that they know that they've had personal identifiable information taken, then they have 10 days to notify the business that the data has been taken.
Okay, all right.
Then we go to Delegate Queen.
Thank you. I just want to clarify in the notification. So primary notification, if I have their email address, phone number, postal mail, or telephone number, I can send it directly in any of those modes, correct?
Correct.
And then secondary, you talked about print media, not social media, but how about radio or public TV? Could that be considered secondary?
I think that's considered broadcast media.
Okay, thank you.
Delegate Howard. Muted.
You're muted, Delegate Howard.
You're on mute.
Yeah, sorry, guys. Sorry about that. Ned, what were you just saying again? I'm sorry. I started listening to Pam. What Pam was talking about. Oh, my point. Okay, never mind. I got it back. Senior moment. But my point is that a lot of these small businesses don't have a complete email address, and a lot of them are opt-in for the email address. So regardless of how the notification is going to go down, you're going to have to do both email and print media. Are we, that costs money. I mean, you're talking about some really small businesses out there that if they get breached. Now, what if, this is a question for legal, what if the maintainer of the data decides that in the breach, that data won't be used for malicious intent? What if they decide that, we were breached, but no data was taken, and if any data was taken, it won't be used for malicious intent? Does the notification provision still reside?
Let me check. I'm pretty sure that it does. I think there's a difference between the maintainer provision and the owner and the licensee provision. So the maintainer,
I'm sorry, go ahead. I'm sorry.
The maintainer provision does not have that language in there. So it doesn't say if they reasonably determine that there's going to be some kind of danger to the breach. The owner and licensee provision does have that information.
It seems to me, I mean, if Comcast is going to, and I'm not trying to pick on them, but they're a large maintainer of data in the Northeast Quadrant. I mean, it seems to me if they come to the rational conclusion that they might have been breached, but there was limited information that was taken, or, that it wasn't, maybe it was just somebody, whatever, and they're not going to do anything with the data, that the onus shouldn't be on the business owner. After the conclusion of that investigation, the onus shouldn't still be on the business owner to make notification.
Okay, no. So I'm reading this provision now, and under B2, know that it does apply to the maintainer as well. That they have to determine that it has to reasonably create.
Okay, so if they determine that it does not reasonably create, then there is no notification provision.
Correct.
Okay.
Correct.
Okay.
My apologies.
Well, that's okay. Thank you. I just want to get that clear.
I just have a
Delegate
question.
Wilson.
Council, again, specifically, what information are we trying to protect here?
Personal information,
Such as?
health information, social security numbers, account numbers, things of that nature.
Stuff like bank information, things of that nature, right? that
Correct.
that I maintain. Isn't that correct?
Correct.
So as a lawyer, I do my pay app, which doesn't maintain any documents. It merely takes somebody's information, submits it, and then I no longer have any way of accessing it. There's no responsibility that I have because I'm not holding on to any information, correct?
Yeah, absolutely.
Okay, I just want to clarify for people, these small businesses and the snowball shops,
Mhm.
they're not taking and keeping people's personal information. Very few people are doing this. And I guess if you do at your own risk, but it's not for, the snowball shop, as Seth said, because they're not going to take and maintain their information. I'll take clients when they come in, but I don't keep any of that. I don't have a database. I have nothing that is sent out and it is done.
Or rebuttal, Delegate Howard.
Is an email address considered personal information?
Yes.
Okay, well, I keep email addresses and do customer alerts for sales and specials that are going on. So if I get breached, I understand that was a breach on my end.
Mhm.
But if Comcast gets breached and they do maintain that data, I think what's lost here is that the onus is on the small business to notify customers of Comcast's breach.
So you're saying Comcast breaches your data list of email addresses
Or credit card numbers or whatever identify.
If you keep credit card numbers, that is a problem.
I understand that,
So
but that's the maintainer clause.
No, because you don't. Okay, go ahead.
Maintainer is in the bill.
I don't maintain that.
Comcast does.
And I don't keep any of that information.
Comcast does, and if they get breached, then they turn around and tell you to notify customers of the breach.
No. Why would they? I don't have any of that information. Only they have it. They have a duty to do it, but I don't have any of that information. That's not in my database. Their credit card numbers I don't keep.
So just to be clear, counsel, if Comcast is breached, there's no onus on the small business owner in this legislation whatsoever for the small business to notify customers about a breach at Comcast.
That's not what she's saying.
I'm not 100% sure that that's true.
Right. That's not what she's saying.
Right. Well, she said she's not 100% sure that that's true.
Okay, so if Comcast is the maintainer of the information and there is a
Right.
breach at Comcast,
Right.
then they
have
have
10
to go
days.
and tell whoever owns or licenses that information. So I think that's
So the small
kind of the-
business would be the licensor or licensee
Why would you be?
because you're in a contract with Comcast.
To do what?
I would guess maintain the information.
No. What information would you possibly be maintaining through Comcast?
Mm-hmm.
What information would you be maintaining through Comcast?
Okay.
You're watching their videos. You're watching their cable.
We're just trying to draw a line, CT, between myself, a credit card processor, and Comcast, what I'm trying to do. And if there's anywhere in that contract that says I'm a licensee and maintainer and or licensee of said information, whether I store it or not is irrelevant. I can't store it based on federal law, but or a very limited amount, like last 4 digits of a credit card, time, date of purchase, and amount of purchase. The full credit card number I can't store, but Comcast can. So what I'm trying to draw a line to and clear into my mind to protect small businesses throughout the state of Maryland is, am I a licensee, right? Per a credit card processing company's contract, am I licensee of the data?
I would say I hope not, because you shouldn't be. It's not your job to maintain. Now they have the credit that company may have to owe a duty, but you shouldn't owe a duty. You shouldn't be maintaining any of that information.
Okay.
You maintain people's social security numbers and somebody breaks in, well, yeah, you got to tell them. If you maintain people's, like you said, their email addresses, if you have a list of email addresses, then you got to tell the people that, their email address.
Yeah, on that email address.
It's really easy to do because you send out an email.
Right, I get that. I'm just trying to draw a line between where I am as licensee, maintainer, and notifier.
Right. And I know we worked on this last year. The goal is to we're not trying to hammer anybody or get people in this catch-22.
Yeah, and I also remember the AG's office opposed it last year, but
Yeah, whatever. Council?
Also, I'd like to mention that you have to maintain the computerized data. So let me just mention that part. So if you don't have computerized files, this isn't going to apply. So I think that might take care of the snow cone situation, unless they're like a
Okay.
really, really big snow cone
no,
provider.
I understand. Thank you very much, Council.
No problem.
Madam Vice Chair?
I actually think, just to sort of further clarify, it's probably it's a very awkwardly worded sentence, but it's the one that Tiffany was referring to before. It's on page 4, lines 17 through 21. And I've only read it 15 times, but I think what it is saying is you as a business owner decides, you're notified by Comcast that they've had a breach. And so, and this is the information that was breached. You then as a business owner have to, decide, does Comcast's breach, is it possible that the information you have is also going to be breached? And if you decide, Comcast, your problem, you notify people, it doesn't affect my clients or customers because they're not going to get to that information through me as the small guy or the vendor, that whatever, if they can't
Right.
if the people that did the breach, the security breach, can't get to your information, you can decide you don't need to notify anybody.
Okay.
I think that's the key. And I think most of the time, if it's the big people and the big guys that are breached, you'll be notified that, gee, this is the information, but you're not going to be notified of specific clients. You're going to be told that Comcast had a breach, that they, think so many people were breached, and they're going to notify those people. You probably won't even know who the people are that were subject to the breach.
Okay.
And then the only analysis you have to do as a business owner, decide, is it possible, but that my customer's information is linked in some way to Comcast that could then be technically subject of the breach. But I kind of doubt that's the case, particularly since Comcast probably is not going to tell you whose information got lost.
All right. Okay. Thank you. Good enough.
All right. So we had a motion. Did we have a motion on the amendments?
We did. I don't think you actually did the yay nay thing, but we did.
Okay. All right. On the amendments, it's been moved and seconded. All in favor signify by aye.
Aye.
All those opposed say nay. All right. The motion carries. Do we have a motion on the bill as amended?
Move favorable with amendment.
Second.
Moved and seconded for favorable as amended. Unless there's further discussion, Madam Vice Chair.
Yes.
Delegate Brooks.
Yes.
Delegate Fisher.
No.
Delegate Queen.
Yes.
Delegate Turner.
Yes.
Delegate Rogers.
Yes.
Delegate Carey.
Yes.
Delegate Jackson.
Yes.
Delegate Pippy.
No.
Delegate Mouts.
No. But I want to vote
Delegate
yes, but no.
Delegate Wilson.
Yes.
Delegate Impalaria.
No.
Delegate Branch.
Aye.
Delegate Valderrama.
Aye.
Delegate Walker.
Yeah, I want to protect personal information. Yes.
Delegate Chi.
Yes.
Delegate Adams.
No.
Delegate Arentz.
No.
Delegate Fennell.
Yes.
Delegate Charkoudian.
Yes.
Delegate Howard.
No.
Delegate Crosby.
Aye.
And Delegate Watson.
Yes.
Right, motion carries. You guys are 3 for 3 on these votes. Let's try House Bill 218.
Okay, House Bill 218, kind of similar, but this is about biometric identifiers and biometric information. This requires a private entity to that holds biometric and identifiers or information to develop a written policy that's available to the public and establishes a retention and destruction schedule for this biometric information. It also requires private entities that have this information to store, transmit, and protect it from disclosure. It also requires private entities, it prohibits them from selling, leasing, or trading biometric identifiers. And if a private entity wants to disclose a biometric identifier or information, they must obtain consent from the consumer before they do it. It also adds that a person who is aggrieved by this law may bring a civil action to recover for each violation under this law. There is one amendment. It is sponsor amendment, and it clarifies that a private entity must obtain consent for each disclosure of the information, as opposed to just one disclosure of the information. And that's it.
Delegate Adams.
Mr. Chairman, but for the fact that this has the private right of action, would have far less problems with the bill. It just seems so very unnecessary to be adding that particular priority here, and just wanted to share that with the committee.
Delegate Wilson.
Mr. Chairman, unfortunately, I kind of agree with Mr. Adams on this. I've noticed, especially in this last year, a lot of these private right of actions, especially when they have attorney's fees involved. And I've noticed, I've had several instances with clients where they're being punished, not for the accusation, but for the mere fact, well, more for the accusation than they did something wrong. And they're terrified of the attorney's fees that they're going to incur. They know that they're not wrong. They didn't do anything wrong. We pass a lot of these laws that we allow damages and treble damages, but we also allow attorney's fees. So you mischaracterize somebody in their employment. That's, a $75 maybe difference in pay. It ends up being a $75,000, damages when it comes to attorney's fees. And I'm worrying that we're continuing down that path by opening up and basically creating these little boutique causes of action for lawyers. Can counsel tell me what the enforcement mechanism is for this one? Is there attorney's fees involved in this one as well?
Yeah,
I am not.
there is. The last page of the bill.
Yeah.
And a lot of times these cases are
Yes.
really slim, if not for the attorney's fees that are going to be piled on ridiculously. And that's where I think the injustice may come in. So I'm a little concerned with that part of, us continuing to push all this stuff, creating new causes of action for plaintiffs' attorneys.
Is that it? Were you?
No, Delegate Queen.
No, I
has her hand
mean,
up.
was Delegate Wilson finished?
No, I was hoping to get some clarity if I was wrong, mistaken, or if I was going the wrong path. Maybe somebody else will bring it, clarify my thought process here.
So on the last page, page 6, you can get reasonable attorney's fees and costs, including expert witness fees and other litigation expenses,
Right.
as well as other relief, including an injunction as the court may deem appropriate.
All right, Delegate Queen.
Thank you, Mr. Chair. So I guess for me, since I'm not a lawyer and I'm trying to, and I don't know when private right of action should or should not be used, and I certainly don't want to create a new role for plaintiff attorneys to get undue fees, but we're talking about information related to people's biometrics. We're talking about information about their fingerprints, their eye retina, stuff that they cannot easily change if it's breached or if it's sold to someone.
Yeah, I'm doing my-
To me, it seems like it's a pretty egregious thing to do. And so how do you make sure that folks are taking extra care of this information? What is going to be the hammer for that? I mean, I definitely don't want to see lawyers making money but I want to see people protected. So tell me the compromise.
Removing the private cause of action. Have the AG do their part, just removing the private cause of action.
And have we not talked to the AG about doing it? Why has it never been brought up? Because this bill actually passed last year through our committee and off the floor. So why was that never part of that?
I just had the experiences I had last year. That's the thing about, what we do for a living. I've had several experiences this year of individuals getting sued for minor infractions for vast amounts. We're talking $150,000 on basically a few hours of unpaid wages.
Yeah, but this is not minor, I don't think, but
No,
I'm open to it. I just want to know why this didn't happen before. Is there anyone else wants to weigh in?
And Mr. Chair.
Delegate Crosby, then Delegate Charkoudian.
Yeah, if we remember from the hearing, the AG's office couldn't enforce. So if we take out the private right of action, that's the only way to keep companies honest and ensure that they keep the data safe. And if I'm not mistaken, the lawsuits that were filed in Illinois, that provision was actually struck out of this bill. And we discussed that at length during the hearing. So I guess the question would be, how else, if an individual has their iris or identity stolen, how else are they going to recoup or enforce this bill? There's no other mechanism, because the attorney general said that they couldn't do that, if I'm not mistaken.
And
Mr. Chair,
go ahead.
I believe if we gave the Attorney General the power to do so, they could,
Right.
just as they have the power to proceed against an unfair trade practice or any other sort of consumer rights, whatever. They don't want to do it because they think they are overworked as they are now, and that, may be the case, but there is certainly a way for there to be civil penalties through the AG's office, through probably the Consumer Protection Division, to indicate that this is, an inappropriate action, and that there could be civil fines. And if it's a business that has a license, that the AG can certainly recommend that the license, certain licenses be taken away. And, and I appreciate this, and said that I would try and stay somewhat out of this, but I missed it last year, to be completely honest. My rightly or wrongly, my experience on the Judiciary Committee, we very seldom provided a private right of action. And I just didn't see it last year. But I know it was there and I voted for it, but I didn't see it.
Delegate Charkoudian.
Thank you, Mr. Chair. I think Delegate Queen's questions were sort of along the lines of the questions that I was asking, and just trying to figure out how to have the right incentive mechanisms for something that's as significant. I mean, I've had my identity stolen, so I kind of have a sense of what a disaster it is to plow your way out of that. And that was just, my numbers, not my physical, identity. So, I don't know if it makes a difference that it says that it's someone who negligently violated it. I mean, so it's not like you could make a mistake on $75 or make a mistake on, accidentally sharing someone's iris. And I guess my concern would be if we make it the Attorney General's, which I'm open to, and I trust that they generally do a good job, is just that there would be sufficient funding for them to actually be able to pursue these. And I mean, that would be my concern if we go in that direction.
Delegate Fisher.
Thanks, Mr. Chairman. My only 2 cents on this is I would love to see more privacy protections, but for me, the appropriate venue or appropriate vehicle rather would be to have the General Assembly pass a bill that says that we individually own our own data and it cannot be used. It belongs to us. I would love to see that. And I know that that's a Herculean task, but given, the constant intrusion, for example, I'm working from my Mac now at home, and it has a biometric identifier for my fingerprint, right? Just to be able to get into it. And there isn't a day that goes by that I keep thinking to myself, my God, who has this information, right? I mean, you know, somebody could kind of use your fingerprint if they stole it and commit a crime and literally frame you. I mean, there's just so many possibilities. So I get it, I do. And I appreciate the private cause of action limitations that CT wants to kind of put the kibosh on. But I just wish we had more of a comprehensive bill that basically said, you own your data, it belongs to you. There are no exceptions and it cannot be sold. That's it. Thanks.
Delegate Walker.
Thank you, Mr. Chair. I'm just kind of hearing this information and here having, you know, Adams and Fisher and Wilson and Dumais on the same page kind of has me wondering, is this something that are we up and down voting this right now? Just something that
well, Dumais is the only one that's the odd one out of that. The other three together, so don't let that throw you. But what I was going to do after I let everyone talk, I was going to hold the bill until we can have, I can see if I can get everybody more on the page. It's for me to press ahead on this. I want to make sure everybody's comfortable. And it's an important bill no matter where you are. So I want to make sure that all the questions are cleared up and
Mr. Chair, well, are we going to task the lawyers, the CT and Dumais to draft something that would
Sure, happy to.
Attorney General to do it so we can review that?
Yeah, I'm going to talk with. I'm going to get us together and we'll talk and see exactly what we need to do and.
Okay, thank you.
I have another question, although I think Delegate Adams was first.
Yes, Delegate Adams, then Delegate Dumais.
I was just going to say, well, you know what? How about if I just keep my mouth shut and let this go? I'm fine right now.
Madam Vice Chair.
I actually have more of a technical question. I was reading through all of the testimony this afternoon, and is facial recognition a biometric fall under this bill?
Let's see.
And I can't tell if it does because photographs don't.
It's not there.
I was just about to say that.
Hold on a second. Delegate Rogers, we can still hear you. Can you mute, please? I'm sorry. Go ahead.
And this might really go to the reason why perhaps it needs a little more. After reading all of the testimony, I'm not as clear of what is covered under biometric information. I mean, I understand fingerprints. I understand iris identification. But a lot of the testimony also talks about facial recognition and some of the prior litigation and whatever was about some of the programs that I think, plus I think this is already covered by federal law. Some of the Facebook and social media that had automatic facial recognition, and there were suits about whether or not that's appropriate. But I can't tell if facial recognition is included in this definition.
You know, it is not clear. It says unique biological characteristic that can be used to uniquely authenticate an individual's identity. So it could fall under that, but again, it's not clear. And like you said, it also says an identifier does not include a photograph. So no, it's not 100% clear.
Not.
And then again, reading the fiscal note, there are several federal statutes that cover some of this. And I just concerned that we haven't completely evaluated whether or not. I mean, you know, the fact that we're asking businesses to have a policy, I don't have any problem with that. But I do think we just need to be sure that our definitions are clear.
Can we hold it, Mr. Chair? Can you unmute yourself first?
Don't be a wise guy. I'll get us together and we'll get all the issues ironed out and bring it back up. If anybody has any questions or anything like that, please submit them to council. She loves those things. So please submit all your questions and thoughts to Ms. Clark, and and we'll see if we can get it all ironed out for you so you all can get comfortable. Let's go on to House Bill 261, please.
This is the bill that generally defines a battery charged fence system as a security system and establishes a basic regulatory framework and limitations for local governments. It came out of business regulation favorable.
Move favorable.
Second.
Discussion.
Second.
Anyone? If not, there's a favorable for House Bill 261. Madam Vice Chair.
Yes.
Delegate Watson.
Yes.
Delegate Crosby.
Aye.
Delegate Howard.
Yes.
Delegate Charkoudian.
Yes.
Delegate Fennell.
Yes.
Delegate Aaron's.
Yes.
Delegate Adams.
Aye.
Delegate Chi.
Yes.
Delegate Walker.
Yes.
Delegate Valderrama.
Aye.
Delegate Branch.
Aye.
Delegate Impalaria.
Aye.
Delegate Wilson.
Yep.
Delegate Mouts.
Yes.
Delegate Pippi.
Yes.
Delegate Jack.
Yes.
Delegate Carey.
Yes.
Delegate Rogers.
Yes.
Delegate Turner.
Yes.
Delegate Queen.
Yes.
Delegate Fisher.
No.
And Delegate Brooks.
Aye.
I'm sorry, Delegate Brooks.
Aye. Yes.
Thank you. Motion carries, I think it's 22-1.
Fisher wants a recount.
22-1. Let's go to House Bill 314.
Okay, ECM is secondary to ENT on this bill. This is a Plastic Bag Reduction Act. And it prohibits retail establishments from providing plastic bags to customers except in certain circumstances. And each individual county is to enforce the provisions of the bill. So ENT voted this out favorably with no amendments.
No amendments, or there were amendments?
No amendments.
No
favorably.
amendments.
It's just as it went out last year?
Correct.
All right. Delegate Howard, then Delegate Adams.
Thank you, Mr. Chair. Do you know, I heard Trader Joe's is like, can't get paper bags because they're so backed up after this passed in New York that there's a waiting list for like 4 years, 3 or 4 years on paper bags on an organization the size of Trader Joe's. I mean,
I am not sure about that. I did not read that in the testimony.
I understand that was some of the testimony in the Senate, maybe.
Maybe.
Okay, maybe it was last year's testimony. I know that there's a huge, this went down in New York and New Jersey, and it's caused a huge back order on paper bags. And which means they're, taking down trees and others to use for paper bags instead of plastic. So it's, kind of like jelly in your hand. You squeeze it, it comes out one direction or the other, maybe both. But okay, thank you.
Delegate Adams.
Thank you, Mr. Chair. So to council, and I was part of the jointly assigned, so I paid attention on ENT a little bit. The first question I have is, didn't Baltimore City have this as a local regulation and held off on this, actually held it off?
Yes. So I should also say that if a local jurisdiction already has something in right now, like they have a local fee on non-plastic bags that was in existence before, I think it's February 1st, 2021, then that still stays. And after this bill passes, no local jurisdiction will be able to pass something that is contrary to this.
Yeah,
so
so the
this is
reason
going
why
to preempt local law.
Yeah, so the reason why I bring that up is that the reasons for Baltimore City doing this,
Trying to say our packages.
economic reasons, not necessarily environmental reasons. So it doesn't surprise me that Environment and Transportation would press a bill, and I would ask the committee to strongly consider the economic half of that, which did address. And I'll add to you that if you're working in a grocery store, for example, you don't want to, and this is testimony that's coming on this, you don't want to touch somebody's reusable bags. You want a new, plastic bag.
Green didn't
Here.
zero.
I'm
Mute
sorry, someone's
yourself.
talking.
Delegate Turner, mute yourself.
So if you're working in a grocery store, if the question in COVID environment, are you wanting to handle somebody's reusable bags? So you've got employees that are concerned about that as well. They should. In fact, one of the bills that we're discussing is the chairman's bill related to essential worker protection. So, I think there's a health aspect to this. The truth of the matter is that, in our committee, I think we have this, the responsibility to make sure if we pass a bill like this, that it matches the ability for us to pass this mandate on to the small businesses and their employees. And I would encourage the committee to, consider that in light of the environment we live in today.
Let me try to remember them in order. Delegate, how are you? Have you spoken or are you up again?
No, I did. I'm sorry, Chair. I'll put my hand down.
No problem. In order, Delegate Walker, I think it's Delegate Chakoudian, then Delegate Crosby.
Thank you, Mr. Chair. So just so I can clarify and know what I'm voting for. So in Prince George's County, we currently don't have any fees or prices for the bag. So if I vote for this bill, what am I saying for Prince George's County? They have to come up with a way to start charging bags?
No,
Okay, so that's why I'm looking. You tell me, what effects will this have on Prince George's County?
no. So whatever, if Prince George's County had something, then whatever they had in law.
We
this
have
would-
nothing right now.
Okay, so then it doesn't really have an effect. They just can't provide plastic bags to people now.
So this would ban plastic bags in Prince George's County.
In retail establishments under certain circumstances. So like, if you have fish or something like that, you can give somebody fish in a plastic bag, or you can give a newspaper in a plastic bag. But if you're just like a carry out bag, you will no longer be able to, retail
what about
establishments
grocery
won't be able to
stores?
give those.
What about grocery stores?
Oh, that counts, yes.
That counts, meaning they could provide you the bag or they would
They
not?
cannot.
Right.
They cannot provide a plastic bag.
So how would a grocery store be able to provide a plastic bag to people that want plastic bags? They'd have to come up with a fee to charge them?
They can't.
It's prohibited.
They cannot.
So this is banning plastic bags.
So the theory is that, you're encouraging people to use reusable bags.
Yeah, and when's the effective date on this?
22, let me see the exact date. Hold on. July 1st, 2022.
22, so we should be out of COVID.
Mhm.
All right, thank you.
Delegate Chakoudian.
Thank you, Mr. Chair. I just wanted to clarify, is this the same, this is the same bill we passed last year, is that right? Out of
Correct.
ECM as a second?
Correct.
The same posture, okay.
Yes.
And I just wanted to clarify a couple things. I think they may be clear, but just so we are clear, it bans the plastic bags, it doesn't ban paper bags. So grocery stores that want to hand out paper bags as opposed to requiring a reusable bag can do that, is that right?
Correct.
And I think that the reason for the extended time frame to go into effect has to do with the ability of stores and also the whole state to be able to kind of get orders and manufacturing in line to be able to prepare for the paper bags. I do want to add, well, I agree with, who said it? Someone said that, paper bags certainly have a negative impact on the environment in terms of using trees, but all in all, from sort of cradle to grave, paper bags are much less damaging than plastic bags are. So certainly bringing your own reusable bag is preferable, but paper bags are way more harmful. Plastic bags are way more harmful. And the only other thing that I wanted to say, because I did look into this early on, because Montgomery County has the limitation, the ban on the plastic bags. And so we looked into this question about around COVID And they're just really the science that, and all the information we have now, there's nothing to suggest that plastic bags are any more hygienic than anything else. And in fact, you know, the health dangers that come along with plastic in the long term are just much worse for our bodies than any sort of perceived idea that plastic bags are somehow helpful in a pandemic context. But a lot of places like Montgomery and other places that had limitations on plastic bag use kept them in place after looking at what the science actually said about COVID and COVID transmission.
Delegate Howard. Oh, Crosby. Delegate Crosby, then Delegate Howard.
Thank you, Mr. Chair. Two things. First, Council, the sponsor approached me about an amendment that we worked out with the Farm Bureau, and we kind of emailed it over late because we've gotten several different amendments that were incorrectly drafted. And I'm not sure if they're in your possession, but Delegate Learman is aware of it, and Chairman Barve is expecting it as well. And basically the amendment would just say that farm stands and farmers markets can use plastic bags. Is it too late to do that? I don't know how that.
I believe it would have to go through the process again because ENT has already voted on this favorably.
Unless it was a floor
in their
amendment.
primary.
Yeah, so from my understanding, and when Delegate Learman sent me the amendment, is ENT voted on it, and it was too late, I guess, through their process to add the amendment, which she agreed to. So she sent it over to me and told me to add it on during ECM. So I don't even know procedurally if I can even do that, or we can.
I think here's I guess let me think through it. I mean, here's the issue. It's not really between the sponsor and so forth. It's the committee. I don't know what ENT, if they are generally favorable to it, to avoid the process, we could just offer it as a floor amendment and then they don't have to go back and re-vote it. But we don't know where they are, it sounds like.
So my understanding, and I can confirm again with Brooke, but I do have the email, or excuse me, Delegate Learman, who I do have the email, is that Chairman Barve is expecting this, and he's accepting of it. So I don't know if that changes anything. I'll do whatever you want, Mr. Chair.
Give me a second. I'm trying to do it where it's most efficient.
I mean, it could be as the floor amendment, particularly if it was an ENT floor amendment. You know, the committees could be either taken off the floor or polled in some form or fashion to determine.
You know what? It's still.
But it's
early
probably
in
ENT.
session. You know what? It's still early in session. Let's vote it. We'll put it on. If there's any misunderstanding, I guess they'll ask us to recede or something, and we'll see. But I'm going to assume that the information is correct. They can accept it, I guess, as a floor amendment, or if they want to go back and redo it in committee. It's just February 15th. So let's.
Sure.
If you're confident, Delegate Crosby, in the information, then we'll go ahead and let's. Well, do we Denise or Bob or whose bill is this? Which one of council? Is it yours, Tiffany?
Mm-hmm.
Do you have it?
No.
Oh, then we won't do that then. Guys, I tell you what, this works perfectly. We'll hold it until council gets in possession of it. And then in the meantime, I can clarify now with ENT, check with Chairman Barve, and we'll figure out exactly how to proceed with it. So this is perfect. We'll let council get in possession of the amendment before we vote on it.
Mr. Chair, can I ask one question for research purposes on this bill?
Yep.
Just if you can let me know, I want to make sure that if this bill is enacted, let's suppose that Prince George's County wanted to impose a fee, a bag tax or bag fee. With this, I want to make sure this would prohibit them. So
that's accurate.
So I will say, so any fee that was in existence on February 1st, 2021, that still stands. Anything after that does not stand. You cannot do.
But you can't give
So
up.
for instance, like Howard County right now, they have fees. So if this were to pass, their fees would still stand. Prince George's, if they wanted to, it would be, if it was in existence by February 1st, 2021, then it would still stand.
So they
So
can
like
have.
Montgomery County, Baltimore City, I know they've got fees. Their stuff stays in, keep it going.
So are they allowed to have plastic bags because they charged fees before 20?
No,
No.
like a paper bag.
Oh, paper bags. Oh.
Yes, so you can charge for a paper bag right now. And under this bill, if you still wanted to charge for a paper bag and you were Howard County who charges for paper bags, then you could do it. But Prince George's County, who does not, cannot do it.
So
under
what
this
about
bill.
those jurisdictions that have plastic bag taxes, fees?
No,
Plastic bags are gone.
no.
They're
it's
gone,
just
so they
gone.
can't
You
have-
They're
just
gone.
cannot
If this
use it.
bill,
You are
right.
prohibited
This would get rid of it, even if you want.
completely.
All right.
Yeah, look at it this way, plastic, if this bill passed, plastic's done. You can't buy your way into it. The only discussion now is on paper. Delegate Jackson.
I'm just curious concerning if we're banning plastic bags, does that mean will be an increase in the amount of trees we're harvesting to produce paper bags?
Quite possibly.
Yes.
Yeah, because I'm thinking to Delegate Charkoudian's point, I mean, while plastic bags are not harmful to the environment, so is not having trees that we need to breathe in our oxygen. So I was just curious if we had any information that would there be an increase in the trees that we're harvesting since we were no longer using plastic bags.
He's overdue, Richard. May I respond?
Sure.
I mean, I can get you the science of sort of life cycle of paper bags and plastic bags and impact on the environment if you want. You're right that paper is not ideal either. Reusable is preferable, but the science of from extraction to production to the fact that plastic lasts in the environment forever, to the fact that it gets into our bodies and causes physical health harm, the comparison of the two net impact on the environment, plastic is much worse. That's sort of what the science is. And if you want, I can track down some information that kind of lines them up against each other and send you that.
Thank
you. Delegate Pippy.
Just Delegate Crosby reminded me, so that floor amendment excluding orchards and farms came out of my district last year. It just dawned on me. And I don't think that's in the bill now. Yeah, if you're planning on holding it and we could do some research on that piece, that would be great, because there's a big contingent, I think even in Montgomery County that.
Yeah, it was.
Yeah, so because I know Delegate Learman was supportive. I mean, it was a floor amendment, which rarely happens, especially coming from a minority party. But it's a good thing if we could exclude those orchards and farmers. They would help a lot of people out in all sorts of counties. So look forward to that. Thank you.
Delegate Ahrens, and then Delegate Turner.
Thank you, Mr. Chair. Council, is there any history of what this has done to, like when these bag prices go in, what it's done to prices? Are costs going up for the consumer?
I mean, the cost is going to go somewhere, and there was testimony that is the case.
Cost is going to go somewhere.
I guess my point would be is that, we're looking at a lot of, these are bad times, and I understand the bill doesn't go into effect for a while, but we just keep adding a penny here, a penny there, and a penny here, and a penny there. And these dollars are adding up. And I just don't know that I can support a bill like this at this point. But I know it doesn't go into effect theoretically, but you're seeing the ramifications of it now. So I'll probably be a nay on this bill. Thank you.
Delegate Turner.
Thank you, Mr. Chairman. My concern is for the seniors. Did they put in this bill about, we had a problem before in Prince George's County about our seniors being charged for the brown paper bags, for the plastic bags. I mean, is there anything in this bill this time around to help our seniors? As he kept as the delegate keeps saying, a penny here, a penny there, a penny there. But how are they help our seniors that goes to the grocery stores and all that stuff that don't have any money right now?
I don't think it's mandated that they have to charge that.
It's not.
Matter of fact, and where we live, Delegate Turner, it's not. The delegation keeps voting against allowing that, and if it were to pass, once it becomes effective, then it couldn't be done. So not to be parochial, but for our county and in your district, it's not an issue. They wouldn't be allowed to charge. For the rest of the state, it sounds like there are a handful of jurisdictions who currently have a surcharge in place, and they would be allowed to keep it because it's already in place. But if you don't already have whatever the date is, a date of enactment, then you would be locked out unless we revisited the decision to allow, I guess someone could file a local bill to have the General Assembly to reconsider, but they wouldn't be able to do it on their own at the county level.
Okay, Mr. Chairman. I don't like this bill. Thank you.
Delegate Chi.
Thank you, Mr. Chair. Just want to respond to Delegate Pippi's earlier point about farms and orchards. Actually, on page 3 of the bill, line 7, it does include that exception. It says a plastic bag provided at a farm or an orchard that contains fruits or vegetables that were produced by and purchased on the farm or orchard. Because I represent a district that includes farmers. So this is there, just for your knowledge.
Thank you. Sorry.
Yeah.
Hey, Delegate Chi, we changed that, and it's that exact language. We strike at and substitute by, and then we strike produced, and substitute grown, and then add purchased and purchased on. It's Delegate Learman's language that was added to it, because if not, it would have excluded that.
Delegate Wilson.
Sure. And I guess my concerns were, and I know this bill passed last year, and I guess the whole pre-COVID thing versus post-COVID is now that, I know that the companies are not going to swallow this cost. I know the small carryouts, I know the grocery stores, they're not going to swallow this cost. And it seems like it's going to be passed down to us. I was concerned about the trees. I'm sure we could I tried to research some biodegradable plastic bags. That there's no such thing. They just become microplastics. The issue with the trees, obviously, and availability of trash bags, of paper bags, is an issue. And last year I supported, in fact, I remember having this discussion saying there was a time that, we all, for a lot of us, that they didn't have plastic bags and we carried our groceries in paper bags. And so my issue now, my nervousness now really just goes with adding any extra cost on in this time in a timely fashion. So I know that we passed this bill out last year. It was voted on, I'm sure I supported it. I just know I'm just a little concerned about the timeliness of this, right now with what's going on. I know we have to do something. I know we have to do something about the environment, and I don't want to keep kicking this can down the road, as I'm sure the chairman doesn't either. That's just a little nerve-wracking issue for me. That wasn't a question. That was just a comment to try and see where my head was at.
All right, Delegate Walker, Delegate Arrington, then remember we got this on hold, so we don't need to keep kicking it around on a hold.
I'll be quick. I just wonder, when my grocery store ran out of plastic bags during this COVID time, they had paper bags they used, and these bags were so much thinner than I remember. They were like tearing like crazy. Is there like a thickness requirement? I'm sure like Delegate Shark may know this, whatever. I know whenever we do plastic bag legislation, there was always we put a requirement in there for 0.00 mLs or whatever. Is there
Yeah.
the thickness of these paper bags that we could put in there?
It says this is applying to, wait, hold on. This section supersedes any law or ordinance of a county or municipality that prohibits, restricts, or regulates the use of plastic bags less than 4 MILs thick by a retail establishment. So I think it's 4 MILs for the plastic bag.
That's for the plastic. What about for the paper bags?
There's nothing in here discussing the paper.
Because I know plastic bags used to be thicker and they didn't float and fly away as much. And now they're like super thin, so they tear a little bit more. And I'm thinking if you're going to have these paper bags, and we don't, the worst thing you could do is have a bag, you're walking out to your car and it gets one little tear and it splits wide open for you. So something for consideration. Thank you, Mr. Chair.
Delegate Queen.
Just quickly, Mr. Chair, because as we go back to discuss this, because I keep hearing about the cost. So we're getting rid of plastic bags. Is the bill saying that we should charge for paper bags now? So okay, so it doesn't talk about passing on the cost for paper bags to
No. So you cannot charge for paper bags either unless you already charged prior to February 1st, 2021. Then you are grandfathered in.
But that was because you charged for paper bags, not plastic bags.
Correct. You can't charge for plastic bags with this law.
I'm trying to understand. For Montgomery County, we charge for plastic bags. We didn't charge for paper bags. So we can't charge now at all either, correct? Right.
Unless you do it in the next month or so, unless they pass an ordinance real quick, I think.
February 1st.
Understood. Okay, thank you.
And here's the thing, guys. Let me close it with this, because I hear some of the consternation and so forth. Remember why the bill was being put forth in the very beginning. There were talks of it clogging the streams and the waste and all of those kinds of stuff that landfills, it doesn't biodegrade and yada, 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 all the arguments for that. So the goal was to try to get rid of it, to get rid of plastics because of the harm that they were doing. The paper originally, the retailers, they actually wanted us to mandate a charge for it because they did in fact wanted to charge. Now, they didn't say it, but it's my opinion, they wanted us to mandate it so that we could be the bad guy when they go up and it's 5 cents a bag or whatever it is. They, I think folks wanted to be able to say, hey, we didn't want to do that. Darn General Assembly, it's mandated. That's why you're paying for this bag. And we wouldn't go for that. That's why that mandated part didn't go in. If anybody's got a bag fee or whatever, it's on them. We didn't put that into this legislation. So I guess what it comes down to, and it's what we need to think about one way or the other as we go, do we still buy the argument of the harmful environmental effects? Took me a while to get there, but I got there personally because I believe it does. Let me just be blunt on this too. I get COVID is a problem now, but we can't use that as a justification for not doing anything down for the foreseeable future. That fog is going to lift. As hard as it is, it's going to lift. And, the economy is going to bounce back and we're going to do things. We can't keep saying, well, we're in COVID, so a year and a half from now, we can't do it, or 5 years from now, we can't do it. We've always made preparations for these kinds of things that allow people to use up their stock and get time to prepare. But, and I mean, I'm hearing it sort of on the floor and other committees and so forth. COVID is now the go-to for everything that we don't want to do. And remember, these are not new things. We didn't want to do them before COVID came, in some instances. So now it's just become another reason not to do it. So I would say, keep that in mind, that COVID isn't going to be with us forever. And we do have to have a plan for going forward, because I know I'd be concerned if we're, still under that fog 3-5 years from now. It's still a COVID dominated economy. So that was mine. All right. In the interest of a rebuttal, I'll let Delegate Howard and then Delegate Adams, and then we will go to the next bill.
Thanks. Council, real quick, what's the fine, if any, in this bill?
One second.
My point with go ahead.
Let's see. A retail establishment that violates this section is subject to a civil penalty not exceeding $500.
Per instance, correct?
Yes, the provision of one or more plastic carryout bags at a single point of sale is a single violation.
And the reason I bring that up, colleagues, is because I shared a story already on the NBC talked about dwindling supplies, and Giant and Safeway, when these bags do come available in the supply chain, will get those because they're going to order 1 million at a time, versus me or anyone else who order 1,000 at a time. So they will fulfill those orders much more quickly. And then ultimately, I'll be subject to the fines when and if these things become even more available. Number two, to me, it's a technology on the municipal level. In Anne Arundel County, we can't recycle these bags because it clogs the recycle machine, whatever it is, but we can't recycle these plastic bags. So that's a technology at the municipal level question. And number three, and I'm not trying to be, I understand, the COVID argument, but when Delegate Walker was saying, we should be out of COVID by the time this bill is, God, I hope so. But at the end of the day, we're coming up on the 1-year anniversary of 2 weeks to flatten the curve. So just something to keep in thought is that, as the supply chains dwindle, and they will, the ones who are going to be hurt and in violation of this are more likely going to be small businesses, because they're not going to be able to fulfill those smaller orders of 1,000, 2,000, 500 paper bags. These suppliers mark my words, they will go directly to Giant, Safeway, Aldi, Lidl, where they're fulfilling 1 million, 2 million paper bags in 1 year per customer. So just something to keep in the thoughts. And I agree. I think it's something we should do, but I think as the technology comes online more at the municipal level, that's where we should be putting our focus on as far as the recycling of these products. The reason they end in landfills is because, for example, I already said it. We can't even put these in the recycle, but these plastic bags in Anne Arundel County, you can't put them in a recycle bin. They won't take them because they can't recycle them. That's just my 2 cents.
Mr. Chairman, just briefly, and again, on the hearing on the environment and transportation side, so this isn't a rebuttal because I'm not the biggest fan of these bags flying around either as an Eastern Shore representative and likes the clean Chesapeake Bay, is that it's a supply and demand thing. So, these paper bags that we're talking about, it's just, can you even get them? So if we pass this bill, if you're talking about 2x4, plywood, the cost of, wood materials, the same logic flows with the paper bags. There's a real problem in the supply chain just getting the plastic paper bags. So the reminder back to what was happening in Baltimore City, I think there were a lot of reasons why they had to hold this off, and not least of which is it may not be 5 cents or 3 cents for a paper bag. It could be demonstrably more expensive, and that's why this bill would provide such an imposition in this particular time frame. Not least of which the idea that you've got people working in grocery stores who submitted testimony during the hearing that they just don't want to touch other people's reusable bags.
Oh, all of those are fair. All right, let's take a breath on that, and let's think through it some more. We've got some questions we need to clear up anyway. So if anybody has anything else they want us to consider, please get it to us as quickly as possible. Whatever happens, I want to be able to take a vote the next time and let ENT know our decision. Let's try House Bill 471, please.
Okay. House Bill 471 requires a financial institution that requires a security question to access account information to have at least 2 security question options to choose from. There are no amendments.
Move favorable.
Second.
Any discussion? If not, Madam Vice Chair,
Yes.
Delegate Watson,
Yes.
Delegate Crosby,
Yes.
Delegate Brooks, Delegate Brooks, Delegate
muted.
Brooks. You got to take
Yes.
Delegate Howard,
Yes.
Delegate Fisher,
No.
Delegate Charkoudian,
Yes.
Delegate Queen,
Yes.
Delegate Fennell,
Yes.
Delegate Turner,
Yes.
Delegate Aaron's,
Yes.
Delegate Rogers,
Yes.
Delegate Adams,
Aye.
Delegate Carey,
Yes.
Delegate Chi,
Yes.
Delegate Jackson,
Yes.
Delegate Walker,
Yes.
Delegate Pippi,
Yes.
Delegate Valderrama,
Aye.
Delegate Mouts,
Yes.
Delegate Branch,
Yep.
Delegate Wilson,
Yes.
Delegate Impalaria.
No.
Motion carries. Let me skip down to House Bill 684 for a minute. Let's take up the professional land surveyors bill if we can.
House Bill 684 alters the definition of practice land surveying for purposes of the Maryland Professional Land Surveyors Act and excludes specified individuals from the general licensure requirement.
Move favorable.
Second.
Second.
Any discussion?
I had a quick question, Mr. Chairman. It's a real
I didn't see
simple
who
one.
said it. Is that Fisher?
Delegate Fisher.
Delegate
It
Fisher.
is, it is. So page 2, line 15, it says the describing, it's adding the word describing. I'm just curious what that means because.
So Delegate Fisher, I don't have the bill in front of me, but I know that during the testimony, there was no opposition. And the whole reason that came to premise is the result of a collaboration between the Board of Professional Land Surveyors and the Maryland Society of Surveyors in trying to modernize right now when it comes to the special technology that's going on as we speak.
So they want this bill because it does what? I mean,
It was basically advancements in technology that are taking place.
I got you. Okay, got it.
Yeah.
All right.
Like 3D scanners and that kind of thing.
Thank you, Delegate Valderrama.
You're welcome, Delegate Fisher.
It's nice. Madam Vice Chair,
Yes.
Delegate Brooks,
Yes.
Delegate Fisher,
Yes.
Delegate Queen,
Yes.
Delegate Turner. You're on mute, Delegate Turner.
Yes. Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippi,
Yes.
Delegate Mouts,
Yes.
Delegate Wilson,
Yes.
Delegate Impalaria,
Yes.
Delegate Branch,
Yep.
Delegate Valderrama,
Aye.
Delegate Walker,
Yes.
Delegate Chi,
Yes.
Delegate Adams,
Aye.
Delegate Aaron's,
Yes.
Delegate Fennell,
Yes.
Delegate Charkoudian,
Yes.
Delegate Howard,
Yes.
Delegate Crosby,
Yes.
and Delegate Watson.
Yes.
All right, motion carries. 577, please.
This is the bill that requires the Secretary of Labor to adopt regulations by October 1st of this year to apply to each employer of H-2A and H-2B visa and migrant workers during the COVID-19 pandemic. The bill takes effect July 1st, 2021. We have an amendment from the sponsor that's in the packet. I can walk through that if the chair would like.
Move unfavorable.
Second.
Second.
Third. We'll see how the motion goes, council. If the motion fails, then we'll come back to the amendment. Delegate Charkoudian.
Thank you, Mr. Chair. Yeah, so I had, during the hearing, I had a number of questions because I was really appreciated and thought there was a value to what the sponsor was doing. I recognize that the bill isn't quite right as it stands, and I had some follow-up conversations with Montgomery County soil conservation folks to try to get some perspective on it and what would be the way to accomplish sort of the goals with the limitations and challenges that are there in the housing. So I was just wondering, did this go to subcommittee or could it, or is it possible to address some of the pieces that are being tried to address here in the broader bill, Mr. Chair, in your bill? Could we work on amendments that tie this in?
It did not go to subcommittee. Quite frankly, based upon what I had been hearing, I had a pretty good idea what was going to happen. So I wasn't going to expend the resources, quite frankly, based upon the hearing and what members were saying to me privately about where they were on it. I was just going to call it for an up or down vote.
I hear that.
Yeah, I mean, unless I've read the group wrong or there's been a change of heart, that it was a strong, consistent, a strong insistence on opposition, to be perfectly honest.
I appreciate that.
The
Thank you.
fiscal note is also $762,000
a year.
Yeah.
There was that.
Yeah, no, and it, you know, I don't know if you remember the questions I was asking in the hearing. I mean, trying to wrap my head around how to get at some of what he's trying to get at without this particular, you know, without the entire bill. And so that's why I was wondering, Mr. Chair, if there's the possibility, if there's something here that maybe fits with 581, if we can bring back the good that might be here, if we don't pass it today, or.
Absolutely. I mean, everything's on the table with that bill. So, I mean, amendments can be offered to 581, the whole thing. I was just addressing like for 577, but if there's amendments to be offered to 581, that would be appropriate.
Okay. So I did have some follow-up conversations after this hearing to see if there's sort of a balanced way to get at some of these issues. So I'll see if I can come up with something that maybe would meet the concerns and still address some of the issues that were raised with the bill. Thank you, Mr. Chair.
Delegate Queen.
Thank you, Mr. Chair. Actually, the comments were made. What I wanted to allude to is I think some of the issues for this bill, the major things that we possibly could accomplish could be done in 581. So I think that's the place to probably look at it. So that's all.
All right. Anyone else? Did I miss anybody? If not, there was a motion and a second for an unfavorable on House Bill 577. Madam Vice Chair.
Yes.
Delegate Watson.
Yes.
Delegate Crosby.
Yes.
Delegate Howard.
Aye on the unfavorable.
Delegate Charkoudian.
I'm going to go with no.
Delegate Fennell.
Yes.
Delegate Aarons.
Yes.
Delegate Adams.
Aye to the unfavorable.
Delegate Chi.
Yes.
Delegate Walker.
Yep.
Delegate Valderrama.
No on the unfavorable?
Delegate Branch.
Aye on it. Aye.
Delegate Impalaria.
Aye.
Delegate Wilson.
Aye.
Delegate Mouts.
Yes to the unfavorable.
Delegate Pippy.
Yes to the unfavorable.
Delegate Jackson.
Yes.
Delegate Carey.
Yes.
Delegate Rogers.
Yes.
Delegate Turner. Delegate Turner,
She's muted.
Wait a minute. I finally got it. Yes.
Delegate Queen,
Yes.
Delegate Fisher,
Yes.
Delegate Brooks.
Aye.
Motion carries.
Is it 21-2?
Yes. Let's go back to House Bill 569 now.
House Bill 569 from Delegate Klippinger takes the current cap in the state on net metering, which is 1,500 megawatts, and doubles it to 3,000 megawatts.
Is there a motion?
I move favorable.
I got a question.
Let me see if there's a second first.
Second.
Is there a second? Going once.
Yes, second.
Second, Mr. Chair.
Delegate Howard.
What? Why are we? I mean, this is like the barrel limits argument that we had for a couple of years. This is what this reminds me of. I mean, in the bill's own fiscal note, it says we're at half capacity as far as these megawatts are concerned, increasing at about 9% per year, and that we shouldn't come up against this until 2026. So I'm a little bit mystified, and maybe someone, I mean, why are we here right now? I don't understand. Anybody want to help me out?
I can take a crack at that, Mr. Chairman.
Sure.
Delegate
That'd be great.
Charcuterie.
Thank you, Mr. Chairman. It's my sense, obviously this is not my bill, but here's my sense of it. Eventually we need to raise the cap because of, we're gonna hit it in a few years.
Yeah, like 6. Like 6, yeah.
Probably sooner than 6, but it's an important cap for folks who want to make sure that there's an equal sort of growth of utility scale solar and rooftop distributed solar. This is the rooftop distributed solar. So it's rooftops and parking lots and so on, the smaller 2 megawatts or less. And so for folks who want to make sure there's a good balance between those two, this is an important sort of way to do that. I think potentially that's why Farm Bureau supported it. I'm pretty sure they did. I could check again.
They did.
Yeah. So there's that piece of it. And then I think there's a sense that because you're trying to signal the market and you're trying to signal investment into one or the other or both, you know, sort of across the board, the sooner you kind of indicate that this is where you're headed, the stronger of a signal it creates to the market. And I can look up, I know that it's not 2026 when we hit the cap. I think it might be 20.
In the fiscal note, it projects 2026 based on the current growth if it stays the same. So you might be right by a year or two, but at the end of the day, I mean, we're 3 or 4 years out.
Yeah, I think that I see what you're saying about the fiscal note. I think that part of the problem is that this past year, I'm not sure why, I haven't seen the fiscal note analysis, but this past year, the rooftop solar industry obviously moved much more slowly because people weren't kind of having people come through there. I mean, it's rooftop, but people weren't having people kind of engaging on their property for that kind of a thing. So I think that I'm not sure if that affects the projection to why they got 2026, but I could look it up if you want. Of what another.
We're not backed up. I mean, we're not even close to the 1,500. We're 50% of the 1,500 megawatt cap. And I just, you know, like I said, it reminds me of all my friends on alcohol subcommittee when we talked about barrel limits. I mean, we were very frustrated with this, the constant, you know, it takes grains of sand to make a heap, right? We're just constantly, we're coming back every year, 500, 1,000, 2,000. And, you know, and we were nowhere near those barrel limits, and we were nowhere near the growth of those barrel limits. And I draw a lot of similarities here, and I understand what you're saying about trying to attract investment, but I feel like that we did that. When was the 1,500 megawatt cap put in?
Believe it's about 1996.
Okay, so we've had 1,500 megawatts for, I don't know, 25 years now.
Well, we've also had, actually, it might have been as late as 2010, about the last time we did we updated the solar band. PSC's latest net metering report suggested that we might reach the cap in 2024 or 2025. They were not suggesting an immediate increase. They were suggesting the General Assembly should discuss it.
So the PSC, so the Farm Bureau is saying yes, move forward to 3,000. We're not up against the limits of the 1,500. The PSC says to hold off for a year or two, and even the best estimates put us coming up against the cap at current growth rates, even a small increase over in current growth rates up to about 2024. So we're still 3 years out.
A lot of that's right, but PSC didn't say hold off. They just said we're not.
Well, that's what John just said.
No, I didn't.
Oh, I'm sorry. Did
I said they thought that the General Assembly should consider it. They didn't say to hold off. They said to consider it now. But that the cap would actually possibly be met in 2024 or 2025 based on a current installation as of mid-2020 of about 849 megawatts in the state.
Right. With about 9% growth per year. Correct?
Yeah, but you also have, I'm not arguing one way or another, but you also have gradually increasing solar band requirements under CEJA.
Okay, thank you, Council.
Bob, are we at, I know there's 300 megawatts in queue right now. Are we at 900 now or 700 or 800 of installed?
I think we're at 900.
The latest report from PSC as of mid-2020 said we were at something like 849 megawatts.
Yeah.
I don't know if we've had any particular increase since then.
Does that include what's in the queue? Because I've got
No.
in the queue.
No,
Okay.
that's installed.
So we're not so far. Okay, thank you.
Where'd he go? So, Mr. Chair, I've talked to the advocates a bit about this, and one of the reasons that they're interested is that community solar is coming online, and what they want to do is to be able to incentivize the market. And that's a large part of the reason, incentivize it and signal the market that this is the direction that we are hoping that the state will move, and that people will in fact do the right investments and use more solar. So that's the reason for I've been told the bill was put in, was to sort of be a signal and incentivize the market. And with community solar coming on, we actually do think it's going to increase more quickly than it has in the past.
Delegate Wilson.
And Chair, I guess 2 questions. One, I guess, because although we haven't reached our limit yet, I think as we move forward and solar gets cheaper and more affordable, I believe that a lot of people are going to. I think that's going to increase without a doubt. But if the council could answer the question, did the co-ops oppose this bill?
Yes. So did the investor-owned utilities.
Okay, thank you.
Delegate Adam.
So I wanted to ask the council as well. I'm trying to recall the hearing, but the question goes to the subsidy, and are we concerned as a policy that we are impacting low-income users by advocating this way? I mean, there is a subsidy, there is this incentive for people that can and are able to do this sort of investment, but does it not come at the expense of the ratepayers overall, i.e. raising the rates of those that are less able to afford it?
I haven't seen any neutral testimony on that. That's what Ms. Connolly testified from Chop Tank. I've recently seen a study from Michigan Technical University suggesting that the overall system benefits are greater than the detriment, but it doesn't tie into particular income classes.
Thank you. I mean, I guess my concern on a bill like this really does come down to who pays and who's able to pay. I think the timing, again, we had this conversation on the plastic bag ban. We can surely have it on this particular bill. That we're in a COVID environment. Is this the year to be raising this sort of goal? Are there in fact other ways that we could approach this? Is Public Service Commission actually encouraging the General Assembly to look at ways other than trying to raise the cap to achieve some growth in renewable energy? And I think the answer could be yes. And my last statement on this is that in a political sense, I'm very concerned that ratepayers that are least able to afford this sort of thing over time are going to be dealt the imposition of paying for it. And with that, I hit mute.
Delegate Crosby.
Thank you, Mr. Chair. Bob, can you explain the relationship between lifting or raising this cap and then the 14.5% solar carve out under CJIT? And then, does this drive investment, raising this cap, does this drive investment for solar, or does the 14.5% carve out drive investment, or is it some combination of both?
Well, I'm a lawyer, not an economist, but I will say that both, we've heard testimony, I think that both are factors, both the ability to have more that are specifically net metered, and then also the 14.5% is for the overall solar rec requirement, which would include both rooftop, any community solar that uses this, as well as utility scale solar installations. What I do recall from the testimony is that net metering is used not only for rooftop, but is also used typically in farm operations, which is why the Farm Bureau came in to support it. That was from their testimony.
Thank you.
Delegate Charkoudian.
Thank you, Mr. Chair. Yeah, so I am also concerned about low-income ratepayers, and just wanted to add that to the Vice Chair's point, the community solar folks who are a big part of this effort in order to grow community solar, that is the way that a lot of folks who can't afford to put solar on their roof can access solar. And a lot of the community solar programs both save ratepayers money, everyone, low-income ratepayers, and many of them have two separate programs, one for low-income ratepayers, which saves them an additional amount above and beyond the sort of standard amount that's saved to everybody. And so I think, more broadly, I would have concerns about equity in terms of who could benefit from a particular investment. But I think the community solar piece of it has sort of changed what's possible around solar. And to the extent that the community solar folks are some of the ones who are advocating for this, it makes me hopeful that this shift actually will be really beneficial to low-income ratepayers. And I'll just say that if I had sent a follow-up email to Delegate Walker. If anyone wants information about how to make sure your constituents know how to benefit from any of that stuff, I'm happy to follow up and point you in the right direction for town halls and so on. Thank you, Mr. Chair.
Delegate Howard.
Where'd the 3,000 come from outside of the legislation and the bill sponsor? Does anybody know? Legal, do you know? Council, do you know where the 3,000 come from?
For me, I just think he doubled it. What, currently 1,500?
Yeah.
Correct.
I didn't know if it was on some type of recommendation, who that recommendation came from.
I don't know, but it's the original number 1,500 itself was out of clear error, but
okay, I'll contact him and try to get, okay.
Delegate Adams.
Mr. Chairman, I guess I will rebut Delegate Charkoudian's point and just say that if we increase to the 3,000 megawatts, the cross subsidy will increase to about 210 million, and residential customers will be paying $67 more per year on average to support the cross subsidy. And the point that I'm trying to make in responding to the delegate's point is that low-income customers are less likely to benefit from this sort of program, notwithstanding community solar, et cetera. It's a matter of degrees, but at the end of the day, is this the year that we want to signal this position, this political position to grow solar? I can't imagine, but that's, I would oppose this bill for that reason alone, just bad timing.
Anyone else?
I think we have a motion on the floor.
Okay, there's a motion, and was there a second?
Second.
Well, yes, there was.
Okay. Madam Vice Chair.
Yes.
Delegate Brooks,
Yes.
Delegate Fisher,
No.
Delegate Queen,
Yes.
Delegate Turner,
Yes.
Delegate Rogers,
Yes.
Delegate Carey,
Yes.
Delegate Jackson,
Yes.
Delegate Pippy,
No.
Delegate Mount,
No.
Delegate Wilson,
Yes.
Delegate Impalaria,
No.
Delegate Branch,
Yep.
Delegate Valderrama,
Yes, on the favorable.
Delegate Walker,
Yeah.
Delegate Chi,
Yes.
Delegate Adams,
No.
Delegate Arentz is excused. Delegate Fennell,
Yes.
Delegate Charkoudian,
Yes.
Delegate Howard,
No.
Delegate Crosby,
Yes.
Delegate Watson.
Yes.
Motion carries. All the bills that we have before you guys. Public Utilities Subcommittee, be on the lookout for emails, please. Are any other subcommittees gonna be getting together this week? Delegate Wilson, did you all have a rescheduling?
We had our subcommittee hearing today. It got a little bogged down, so I'm hoping we can do it on Thursday. I asked all the subcommittee members just be a little loose on this. We're going to try and get another one in today, or not today, this week. Thursday's what we're shooting for, 12:30, but we know that could change.
Yeah, I think we're on the floor,
At
so
10.
it could be tight, but we'll we'll definitely do the best we can.
Thank you.
Mr. Chairman?
Delegate Valderrama.
Yes, thank you. Workers' Comp Subcommittee, I'm looking to put one together. If it's not this week, I'm hoping next week.
Okay.
Okay, you're on the floor Tuesday and Thursday at 10, Friday at 9. Friday, we also have alcohol bill hearings at 11 and again at 1:30.
Okay, then not
Yeah,
this
that's going
week.
to be a long day Friday, guys.
Oh,
Relatively
yeah.
speaking.
Are we on the floor Friday as well?
Yep.
Yes.
Yes, at 9 o'clock.
I asked the speaker to do it just to inconvenience you. So she agreed to do it for me. So
That's just
anyway, yeah,
mean,
Friday's
man.
gonna be long. At 9 o'clock we got some bills at 11. Is it like statewide at 11 and local?
Statewide bills at 11, local bills starting at 1:30.
Okay.
They would have had Friday session at 10, but they knew we had the important statewide bills at 11, so they moved up the starting time.
Yep. All right.
Witness the power of the alcohol subcommittee.
There you go. So
We aim to deliver.
I appreciate it. Appreciate all your work. And this week I could be wrong because I haven't seen the list, but we've got a lot of big bills up this week, so it could be a long one. I know we got the family medical leave bill tomorrow, so I would imagine that could take some time. A number of business reg bills on Wednesday, a lot of energy bills on Thursday, including the coal phase out bill and some other things, and Friday is alcohol. So there are a number of things that I think that will keep us longer than what we have been. So just sort of keep that in mind for scheduling purposes. And with that, and without further ado,
Mr. Chairman, when should we expect these bills on the floor?
say again.
When should we expect these bills on the floor?
Thursday. We're not
Okay.
going to we won't have it tomorrow. Wednesday, we're not on the floor. So we're going to have them on the floor Thursday.
Okay,
All right.
sounds good.
All right, guys. Take care and thank you.
All right,
See you guys
bye.
tomorrow, guys. Have a good one.
Bye.
Night.